Welcome to Legal Shield UK, the channel that explains your rights clearly, simply, and without the legal jargon. Today, I'll show you how to win any complaint in the UK using the law, whether it's a council, a company, a landlord, a school, or even the police. These are the same techniques professionals use, and you can use them too. Let's start with the biggest secret in UK complaints. Whoever has the strongest evidence wins. It is not about emotion, anger, or long paragraphs. It is about proving you're right using the law and documented facts. Before you complain, gather dates, screenshots, emails, photos, receipts, timelines, phone logs, and any policy documents. The stronger your evidence, the faster they give in. If your complaint is about a shop, a service, a contractor, or a business, the Consumer Rights Act 2015 is your best weapon. Under this law, services must be performed with reasonable care and skill. Goods must be of satisfactory quality. If they fail, you're entitled to a repair, replacement, or refund. Here's the trick. Mentioning the law forces them to take you seriously. For example, my rights are protected under Section 49 of the Consumer Rights Act 2015. The service you provided did not meet the required standard, and I am seeking a remedy. This is how professionals word complaints. Most people don't know this, but GDPR is one of the most powerful complaint tools you have. Under Article 15, you can request all data call logs, emails, internal notes, recordings, and decision-making records. This is called a subject access request. Why does this win complaints? Because once you pull their internal evidence, they can no longer deny what happened. If something smells wrong, SAR them. Every sector in the UK must follow formal complaint procedures. This includes councils, police, ombudsman, services, landlords, insurers, debt collectors, energy firms, banks. When you say, I am escalating this as a formal complaint under your complaint handling policy, they must follow a regulated process. If they fail, you can take it to the Ombudsman. The Ombudsman is your cheat code. Because companies hate ombudsman investigations. Why? It costs them money each time it damages their regulatory score. They often lose when a company ignores you. Simply say, if this is not resolved, I will escalate to the relevant ombudsman. This usually forces a response within days. Ombudsman bodies include Financial Ombudsman, Housing Ombudsman, Energy Ombudsman, Local Government Ombudsman, Information Commissioner's Office, Communications Ombudsman. Pick the right one. Here's a structure used by professionals, and it works almost every time. 1. State the facts: what happened, when, and who was involved. 2. State the law. Quote, Consumer Rights Act, GDPR, Housing Act, etc. 3. State what you want: refund, apology, correction, removal of charges, compensation. 4. Give a deadline, usually 14 days. 5. State the escalation ombudsman or court. This makes your complaint look legally serious. Here's a simple example you can use. Under the Consumer Rights Act 2015, the service provided fell below reasonable care and skill. I request a full refund within 14 days. If I do not receive a satisfactory response, I will escalate this to the relevant ombudsman and seek remedies available under UK law. That sentence alone wins more complaints than you think. You can claim compensation when you suffered financial loss, you were misled, your data was misused, there were delays, there was harassment, they breached legislation or policy. Most people don't ask. Those who ask, get it. If you found this helpful, subscribe to Legal Shield UK for more clear legal explanations, complaint templates, and rights they don't want you to know. Let me know in the comments what topic you want covered next.